I should have brought those.
Good afternoon. I'm calling this meeting of the Wausau City Ethics Board at 4:30 on Wednesday, February 19th, 2025. Seeing that a quorum of members is present, I will call this meeting to order. The first item on our agenda is the annual election of a chairperson for 2025. Are there any nominations for the chair position?
Well, I'll volunteer.
Okay, we have Calvin Dexter. Do you accept the nomination?
I accept my nomination, yes.
Okay. Calvin Dexter has been nominated for the position of chair. Are there any further nominations?
Well, I would like to be vice chair.
We will come to that next,
Oh,
Doug, so
okay.
hang on.
Thank you.
I will accept a motion to close nominations and cast a unanimous ballot for Calvin to be the chair.
Okay.
I would second that.
Okay. I will turn the meeting over to Calvin at this time.
Thank you, Kay.
Do we have a vice chair yet?
The next item of business is for the election of the vice chair.
Thank you very
Thank you.
much.
And the chair will accept any nominations or volunteering that might be in order here. Anyone interested in the job?
I love it. I'm already.
You've got
vice-
experience.
I have a lot of experience as vice chair and as an acting chair. I don't like being a real chair. I like being an acting.
You've been a real chair already, too. And so do I take your volunteering to be a nomination of yourself as
Sure,
vice chair?
I'll do that.
All right, are there any other nominations for the position of vice chair? Any other nominations? Seeing none, I'll entertain a motion for a unanimous ballot for Doug Hostler to serve as vice chair of the Ethics Board.
Do we need a second? I will second.
And so we'll, I guess you've got the job then, Doug,
Thanks a lot. Okay.
unless there's any objection from anybody else on the board. The first thing I want to do as chair is to thank Kay Palmer for all the extra time, effort, and work she put in as our chair in the past year. I'll do my best to meet the standards set by Kay and by Doug Hostler, who served as chair before Kay. And in the past couple of weeks, I've given a lot of thought and time to the matter of the complaint that the board has received. I've tried to map out for myself the process that I think the board needs to follow to reach an initial determination on the complaint. And depending on that determination, the options we might have to move forward during this meeting of the board. But I ask for the help of all board members and our outside counsel, Attorney Eric Larson, to help keep things on track. And I think it's important that we get the thoughts and input of all board members. So I ask my fellow members to please feel free to stop me if necessary to make sure that you are heard. The next item on the agenda is approval of written minutes of previous meetings. There are 3 meetings involved. I would, at this time, move to postpone items 2, 3, and 4 until after items 5 and 6 have been dealt with. And that's because we have outside counsel here who's being paid for his time to assist us on those items 5 and 6. And if we can move the other items that we have on our agenda to after that point in time, Attorney Larson can feel free to leave and I guess stop the meter running, as they say. So I've made that motion. Is there a second?
I'll second it.
It's been seconded by Doug Hostler. Any discussion on the meeting, on the motion? Seeing none, we'll ask the clerk to call the roll for a vote on that.
That's not necessary, you can just.
We can just
All approve, say aye, all opposed.
Well, we'll ask for a show of hands then, because I think the record should reflect if we've got any dissent. All in favor, please raise your hand. That's all of us, so the matter is, the postponement is unanimously adopted. Those items will be taken up after items 5 and 6 have been dealt with, assuming we still have time to do that. And now Attorney Larson is handing something out to us, and I assume he'll join us up
I'm
here.
going to join you, and I will explain what I'm handing out
Thank you.
as well.
Thank you.
Thank you.
Doug, I would like to take a moment right now. I am going to recuse myself at this time from this complaint. In my role as a member of the League of Women Voters, a nonpartisan organization, I publicly voiced my opinion on the moving of the ballot drop box and would not be an unbiased participant in the hearing of this complaint. So I will recuse myself at this point.
Thank you for that, Kay. I was planning on asking if there are any recusals, so you got a little ahead of me there, but I want to say that I think your decision shows your integrity and your commitment to the policy that lies behind the ethics code. So thank you for that.
Okay, thank you.
Attorney Larson.
Thank you. First of all, this is the first time I've met you folks, and I just want to introduce myself. I am a municipal lawyer. I represent municipalities throughout the state. I have done so for 35 years. That includes representing ethics boards. So I have done quite a bit of this. Doesn't mean I'm perfect. I'm not saying that I'm perfect, but I am familiar with your code. I've familiarized myself and with the process. And I have some thoughts on,
Excuse me, Attorney Larson.
Yes.
I think we're jumping a little bit further ahead than
Sure.
we want to be.
Go ahead.
So thank you for that. And we'll be looking forward to getting to that handout you just gave us. First, I want to make sure that nobody else wants to recuse themselves from these proceedings. Is that correct? No one else is doing so. And then I also wanted to point out that under the code, if a member of the board recuses herself from serving, that the alternate member of the board, in this case,
Jesse.
Jesse Kearns will step up to full service as a member of the board on this particular proceeding. So we have that. And let's see. So, no, sorry for the
But-
interruption,
but-
but I wanted to cover that before.
Yeah, just make sure that, I mean, Jesse, you realize that. That was the move I wanted to make.
Yeah,
Okay.
absolutely. Thank
You're
you.
good with that?
Thank
I accept, yeah.
Okay.
so our ordinance is quite particular about how our process works. And members of the board, you're sitting here as judges. And as judges, it's your job to follow the process that's described in the ordinance. Our task today is very narrow under the ordinance. It's essentially to determine whether you have jurisdiction to hear this complaint. And that requires you to make a determination of whether the complaint in itself is sufficient. This is what your ordinance says. If you care to follow the handout, on page 1, it says authority, initial determination. This is what your code calls out as your task today. Initial determination by board. The board shall review a third-party complaint at a duly called meeting and determine whether it alleges facts sufficient to constitute a violation of this chapter. So the issue today is, does the complaint allege facts sufficient to constitute a violation of the ethics code? And I'll just point out that the complaint calls out a specific violation that it asserts, which is a violation of ethics code section 2.03.030 sub J. No official employee in his/her official capacity shall do any act or use his or her official title in performing any act which he or she knows is in excess of his or her lawful authority, or which he or she knows he or she is forbidden by law to do in his or her official capacity. So our task today, as I say, is very narrow. You just look at the complaint and you see whether it alleges a violation of the ethics code. Does it present facts that make that allegation? I'll just talk very briefly, just a bit more on that. Our courts face similar issues, and so there is a body of case law on this question of sufficiency of a complaint. And I'll read from a case called Zucchino versus Dane County, 380 West 2nd, 453. It's a 2018 case. It says a motion to dismiss for failure to state a claim tests the legal sufficiency of the complaint. We don't have a motion to dismiss, but we're in that same posture of determining whether the complaint is sufficient. When reviewing a motion to dismiss for failure to state a claim, we accept the facts alleged in the complaint as true and draw all reasonable inferences from those facts in the plaintiff's, in this case, the complainant's favor. To withstand a motion to dismiss, a complaint must allege facts that, if true, plausibly suggest a violation of applicable laws. So, my point is that our courts have determined that this needs to be very broadly read. The complaint needs to be broadly read to make that determination of whether it plausibly suggests that a violation of the code occurred. And I want it to be very clear, we're not making any determinations that it did occur. We're only making a determination of whether it alleges it occurred.
Right.
Does it allege that it occurred?
Thank you for that.
I'll be happy to answer any questions.
No, that sounds good.
There no doubt will be questions along the way. I wanted to make a few remarks as we begin this inquiry. And as in an introduction to this item on the agenda, I want to state that I'm pleased to see residents and news media in attendance. I think there's news media here, giving the people an opportunity to learn how the Wausau Ethics Code works. For more information, please see Chapter 2.03 of the Wausau Municipal Ordinances. And that chapter begins with a declaration of policy that was adopted 35 years ago. And I quote, "Moral and ethical standards among city public officials and employees are essential to the conduct of representative government. And the Common Council believes that a code of ethics to establish standards of conduct for governmental officials and employees by setting forth those acts or actions that are incompatible with the impartial and responsible exercise of the public trust and avoid conflicts between personal interests and public responsibilities will improve the quality and integrity of public service and promote, strengthen, and nurture the faith and confidence of the citizens of this community in their public officials and employees. Note that only the Common Council has the authority to decide what the ethical standards are. This unpaid citizen ethics board reviews and investigates complaints that a city officer or employee has violated the standards adopted by the council. Note also that the ethics board does not make a decision about anything other than whether an ethical standard has been violated. We do not decide issues of public policy. We are pleased to see people attend open sessions of the ethics board meetings to learn about how the ethics process works. A proceeding on an ethics complaint is a quasi-judicial proceeding, as Attorney Larson referred to. We ask that it's similar to a judicial proceeding, and in that vein, we ask attendees to conduct themselves as they would in a judicial proceeding, and please refrain from reacting during the meeting to what board members may say or what action the board may take. At this initial meeting, the board is to make a determination, as Attorney Larson indicated, on the sufficiency of the complaint. At this stage in the process, the code limits the board to making that determination and to decisions on how it will move forward if it determines the complaint is sufficient to allege a violation. Today, the board will not hear from any witnesses, receive evidence, or hear any arguments from the parties. Any other board members that would like to make opening comments at this stage in the process? Seeing none, the first step the board must take is to review the ethics complaint and make an initial determination as called for in the ethics code. As part of our duty to review the complaint, I would like to make a few observations about form and timeliness. As required by the ordinance, the clerk has made the determination that the complaint is in the proper form and has forwarded the complaint and the supporting documents to the ethics board. The complaint is a single document with an attachment and was signed under oath by 4 individuals identifying themselves in the sworn statement as residents of the city of Wausau. The ordinance also provides that no action may be taken on any complaint filed more than 12 months after the violation of the ethics code that is alleged to have occurred. The complaint alleges that a violation occurred during the week of September 23rd in the year 2024. Let the record of these proceedings reflect that the verified complaint was filed less than 12 months after the actions alleged to violate the ethics code. Therefore, the board may take action on the complaint. Any comments from other board members on those observations or observations of your own? All right. Next, the ordinance requires the board to determine whether the complaint alleges facts sufficient to constitute a violation of the ethics code, as Attorney Larson has indicated. Let's note that this is not a determination of the truth of any of the allegations. It is only about whether
Right.
It's only about whether what has been alleged, if true, would be a violation of the ethics code. To begin discussion, the chair will entertain a motion that the ethics board determines that the complaint either does or does not allege facts sufficient to constitute a violation by the respondent of Chapter 2.03 of the Wausau Municipal Ordinances. Do we have such a motion?
Well, I was going to make a comment, just to repeat what you said, is that we're not saying this actually occurred. We're just saying what it alleges.
Right.
Is something that would do that.
It's important
So
to
it's
note that.
Right. I mean, I just like emphasizing that. And given that, I will so move,
You will move which way? That there is,
that there is such. I mean, that's what they're alleging.
the complaint does
That seems
allege-
pretty clear, that it's alleging something that would be a violation.
All right.
But
Is
I
there,
don't know how other people feel.
is there a second to that motion?
I would second.
It's been moved and seconded. We're now open for discussion on that point. One of the things I'd like to say is that I think this checklist that you've provided us will be very useful to
Very useful.
the board members. I'd like to note that the complaint alleges that paragraph J was violated, and that is included on Attorney Larson's handout to us, the actual words of that standard, which he read to us. I note that the respondent is the mayor and therefore clearly is a city official subject to the ethics code. The complaint alleges that an act of the respondent prevented the city clerk from installing an absentee ballot drop box in accordance with the clerk's authority under Wisconsin law during the week of September 23rd, 2024. The complaint alleges that the respondent acted in excess of his lawful authority as mayor when he took the actions described in the complaint. The complaint also alleges that the respondent had knowledge that his actions would exceed his authority because he had prior notice from the city attorney that they would. The complaint also alleges that the respondent's actions violated 3 federal laws prohibiting interference with voting and elections, and that even after being confronted about the alleged violations, he continued to hold the drop box for over a week. I would suggest that this can be construed as an allegation that the respondent, at least after he was confronted, committed acts that he knew he was forbidden by law to do in his official capacity. Finally, the complaint alleges that the respondent attempted to force the city clerk to draft a resolution banning drop boxes, and when that failed, he spoke out of turn about drop boxes at a common council meeting held on September 23rd, 2024. I would suggest that speaking out of turn at a meeting is not a violation of the ethics code. attempting to force the clerk to take some action might conceivably exceed the respondent's lawful authority, in my opinion, depending on what might have been said or done to try to force the clerk into taking the action. So those are my thoughts on how the complaint lines up against the alleged code violation. At this time, I don't think we need to evaluate each allegation made in the complaint to determine whether it standing alone would be a violation of the code. We only need to determine if there are facts alleged in the complaint that, if they are true, are sufficient to constitute a violation of the code. The complaint specifies that the ethical standard alleged to have been violated by the respondent, together with a factual basis for that allegation. Any discussion now? Seeing no discussion, we can call this matter to a vote. And this is on the question, could we have a roll call on this, Cody, or do we not need to do that?
It's not necessary.
I think we want to make sure we raise hands so we have a record of who voted
Yeah.
which way. This is on the question of adoption of the proposed determination, and that determination is stated as follows. The Ethics Board determines that there are facts alleged in the complaint that, if found to be true, are sufficient to constitute a violation of the prohibitions of Section 2.03.030, paragraph J of the standards of conduct set forth in the Ethics Code. All those in favor, raise your hand. We have a unanimous vote determining that the complaint is sufficient. And again, a determination of whether there is probable cause to believe a violation actually occurred will be made by the board at a future meeting. Next item on the agenda would be discussion and determination of the next board action under Section 2.03.060, paragraph C and D on this complaint. That section provides the board with 3 options for additional steps it can take if it determines the complaint alleges facts that, if found to be true, are sufficient to constitute a violation of the Ethics Code. Those steps can include, number 1, referral to the district attorney. Number 2, investigate. Or number 3, proceed directly to order a hearing. My understanding from reading the news is that the city clerk has already made a referral to the district attorney. I would move that we adopt a resolution to investigate prior to making any decision on ordering a hearing. For discussion purposes, I have prepared and can distribute a proposed resolution designed to meet the requirements of Section 2.03.060, paragraph D, which sets forth the requirements for authorizing an investigation. And once I distribute this, I will keep, let's give one to Attorney Larson,
Yeah,
and I need to keep one.
yeah.
And I can, for the benefit of those in attendance who aren't on the board and won't be getting a copy of this at this time, I can give kind of a rundown on what this resolution does. And again, it's designed to meet the requirements for authorizing an investigation. Those requirements are set forth in the ordinance. The initial paragraph reflects that the ordinance provisions and background material on the complaint. And then Section 2.03.060, paragraph C and D of the Ethics Code permit the Ethics Board by resolution to authorize an investigation of the complaint. And paragraph D requires the resolution to, quote, state the nature and purpose of the investigation and the action or activities to be investigated, and a general statement of the statutes and ordinances applicable to the investigation, close quote. Then the resolution continues, accordingly, the Ethics Board resolves to conduct an investigation of the complaint. The nature and purpose of the investigation, to obtain evidence relating to the allegations contained in the complaint. The actions or activities to be investigated, actions and activities described in the complaint generally relating to the allegation that the respondent violated Section 2.03.030, paragraph J, by preventing the city clerk from installing an absentee ballot drop box. General statement of the statutes and ordinances applicable to the investigation, Section 2.03.030, paragraph J of the Ethics Code, and also the United States Code and Wisconsin State statutes relating to elections. A copy of this resolution shall be mailed to the respondent and each complainant. And there is a no contact notice, which reads as follows. Section 2.03.060, paragraph E. There's a typo on my initial printout.
Right.
It's paragraph E, provides that,
No
quote,
respondent.
no respondent who has been notified that he/she is the subject of an investigation being conducted by the board, or who has been notified that he/she is the subject of a complaint filed with the board, shall contact directly or through another person any board member about his/her case, except during a hearing conducted by the board, close quote. By this resolution, the board would extend this no contact requirement to each person who signed the complaint, as well as the respondent. So the actual ordinance provision does not require that a copy of this be sent to the complainants, but I am proposing with this resolution that that be included. Any discussion? See,
Right.
did we get a second on that motion? I don't believe so.
I could second.
Thank you.
Okay.
Doug, you had something to say?
No, it's just particular things we want to do that are in line with this is a further discussion, right? This is just, because there might be certain things, for instance, I would like to know that regard the details. You know, certain, and I want to make, that's because when initially I saw this as part of our agenda, I thought, what, we're not going to actually make a decision at this time as to what we're going to do, just that we're going to do this. And that's sort of, that's what I
Well,
understood.
yeah, what I'm proposing is that we first authorize a resolution as required by, a resolution authorizing investigations.
Right.
Required by the code, and then I will have some proposals for actually commencing an investigation.
With certain things, right.
What kinds of information we're going to be looking for.
But if I looked at the agenda, it looks like we're not allowed to do that at this meeting. We can do what you're doing. That is, we don't decide it until the next one. That is,
Well, I believe we can, well, let's take this as far as we can today, and I
Right,
believe we
sure.
can take this
Sure.
to the
I'm in favor.
investigation.
Yeah, because there are a number of things that I personally would like to see that, dealing with the investigation,
And
that
we-
would fit under this.
That would come up after we decide whether to authorize the investigation.
Right, oh, yeah.
Then we'll talk about what the
But so
investigation
its
may
nature isn't
include.
fully decided.
Absolutely, right. There's a lot
okay.
more to talk
That's all
about.
I care about, yeah.
A lot more to talk about.
Yeah. 'Cause,
So the legal aspect there, a question was raised of open meetings law compliance. And you're both right. You could discuss this today and then come back at a future meeting and decide whether to adopt this resolution. You currently are agenda to discuss and possible, it says discussion and possible action on possible future actions. So that's
Possible action on possible future action.
action on possible future actions. Honestly, it would be better to put the resolution on a future agenda so it's very clear that the resolution is going to be acted on
Right,
one way or another. But
okay. Right,
it's not wrong to say that discussion and possible action on possible future actions means the future action is going to be an investigation.
yeah.
And so you could act on saying you're going to do an investigation. So that's why I say you're both right, in my opinion. But I think I would recommend that you put some meat on the bones, whether you do it today or another meeting, to say, oh, who's going to do the investigation? How are they going to do the investigation? And what are they? you've laid it out in general terms, but what are they looking for in the investigation?
And I have brought meat,
Okay.
so we'll have something to
Okay.
talk about.
Yeah, I will have some too.
Well, I think it makes sense to do an investigation, so if that's the resolution, I do think that our next step would be yes.
If it's-
Versus the other choices that we're given, I think an investigation is important.
Right. If that's, if we understand the motion that way, I would agree. It's just the nature of it, the way I understood it, the actual nature of the investigation. We would start out talking about this, and we'd have time to think until we actually figure which ones we're going to do, and which ones aren't possible. Things like that. That's my suggestion. So if we understand the motion as one that, yes, we're going to do an investigation, I'm happy with that.
Yeah, that's where we are right now.
Okay.
This resolution, that's all we're talking about voting on at this time.
That,
And then I have some proposals to put some meat on the bones.
Sure, yeah.
And we'll
I
see
have
what
a
you
few.
think.
And I have a few too, so.
I'm
I mean,
glad to
things
hear
that
it.
I personally want, I'm very,
I'm glad to hear it.
right.
All right.
Some of them I think I have answers to, but go ahead.
Any other discussion on the motion?
Yeah.
And
Pretty
I'm still,
tired
Cody, do you remember, do we have a second on that? I think.
I think
Rob-
Jesse
or
seconded.
Jesse did, right. Thank you. All right, well, we'll call the question then.
Okay.
Let me get back to it. And the question is that the board adopts this resolution to investigate prior to making any decision on ordering a hearing. So we're voting on the resolution that was passed
To
out.
investigate, yeah,
All those in favor, please raise your hand.
okay,
We have a unanimous vote.
okay.
All right.
Yeah, but things, go ahead. I mean, the things that I have that just I haven't run off is.
Okay.
There are other, do you want to hear those or things I particularly would like to see as part of the investigation?
Right.
But again, I don't plan to act on them at this point.
Well, we'll see what you think when you take a look at them, and we'll talk about. I have handouts.
I don't have handouts.
You don't like handouts?
No, I don't have them.
You're gonna get one.
I came short without handouts.
You'll be the first one to get that handout right there.
I
Let's
can
put one
give it to you
to-
because I'm
I'll
generous.
keep one. Thank you, Cody.
I get another one, thank you. You can give me, no, I got one, I want one. I get, yeah, I gave mine to my friend.
That's nice.
All right. I'm going to ask at this time, does any other board member have other proposals for investigation, or is this basically what we're going to look at first? Okay, it appears that we'll go with this. And again, I welcome critical review. Doug, if you've
Sure.
got changes, or if you think I've missed something.
Sure.
But these are specific proposals designed to implement the board's resolution authorizing an investigation. And the very first proposal that's on this list is, and I'll read it, that the board include an order that the respondent is invited to file with the Ethics Board a response to the complaint that either admits or denies each allegation in the complaint, with any factual allegation not denied being deemed an admission of its truth. Any response is to be filed with the city clerk no later than, and then we can set a deadline for that response from the date of this order. Upon receiving such a response, the city clerk shall without delay forward copies of it to the complainants and to the board. Do we have a motion to adopt that
Okay.
proposal
That
so we can discuss it?
let me read it again, the complaint.
Okay?
Is invited, okay, just invited to file.
Invited, yeah.
Invited to file with the Ethics Board a response to any part of the complaint? Is that really what it says, basically, that response
Well,
to the
we're-
complaint?
we would be-
Each allegation,
He can file whatever he wants.
Right.
But I think the main reason for this is I think the code doesn't expressly provide that a respondent is to be given an opportunity to file a written response
right,
to the complaint. And I feel that as a matter of fairness and due process, the
Right.
respondent should be given that opportunity.
Right.
And that the board's investigation is the place to include it right now, since the ordinance
Mm-hmm. No.
doesn't include that.
you know, I definitely would want that here, yeah.
Other discussion?
Are we going to then include each of these and then say that we're going to include them individually, or is this going to be passed as a whole?
Good point.
Okay.
I would suggest we take each one individually. I expect there will be proposals to amend, or in this case, filling in a deadline, those kinds of things. But in the end, after, and we probably should be taking preliminary votes on them all. But I do envision that this could be, all of these that get adopted could be included in an actual order that would go out to the parties that it's directed to. Good question, thank you. Other discussion?
Well, I think, I don't know if anybody seconded
Oh, thank
that
you.
motion, and I'll second that to
Thanks,
include
Rob.
this.
Are we teaching, we're teaching each one of these items as a motion?
I think so, so that we
Yeah,
can,
okay.
Yes.
That would be
So,
a
just to be clear, the motion is to order
Invite.
item 1. Is that correct?
Right.
And the motion was made by whom?
The motion was not made. I believe the question was, does
I-
anyone want to
I
pose
made
as a
the
motion?
motion. I think, or did, maybe I didn't.
I think you posed the question if anyone would like to,
All
so
right.
if you're inviting us to, I could put
Yeah.
it forward as well.
Yes, that would be better.
Okay,
Thank you.
much better,
Yeah,
yes.
happy to put that forward, and
Yeah,
and I will still second it.
okay, there we go.
Thank you both.
And that's for the first item,
Correct.
right?
First item on that.
That'd be
handout.
something that we see as something we would like to do.
Yeah.
Yeah, and probably the earlier we do this, the better. I don't know.
So-
So
Go ahead.
No, go ahead.
there's a blank
Yeah.
that should be fleshed out?
Yeah,
Right.
we could have a proposal of a particular time frame, and I would like to see that time frame be relatively short. It's my understanding that everybody pretty much knows about this issue, and even I have read that the respondent hired an attorney who produced something that sounds like an answer already, and so it shouldn't take much time to get that to the board or to the city clerk for the board. And in addition, simply answering allegations in a complaint, you say, I admit that allegation, or I deny that allegation. There's very little to that at all. So I would recommend a 7-day, 7 days after this order is signed
Yeah.
and goes out.
I have an item to see if it fits it or not, but apparently the attorney that I think was being used by the mayor has produced a document of saying that the law was not violated, and that there's a, I think I recall, an 8-page set of reasons. And that's something I want to see, but apparently, according to the mayor, it's the clerk has it. As this, because as a philosopher, in case you want to know, this was my career was as a philosophy teacher. I really am not just interested in someone's opinion. I want to see their reasons, and the reasons might be very useful because even if I think there's a problem in the reasoning, it might get me to think about certain things. And so I think it's along the line of what you're doing. I want to see exactly what the set of reasons is that is to show that it is not a violation of the law, because that's a very basic part of the complaint.
I have a question on process. So if, in the event that we were able to obtain this document or the document that's in question, would that been, like, is there an entering into evidence that we are then leveraging and utilizing that is public record?
I'm not sure I'm following.
So if we were to ask for this document, obviously that would be the board's, and then we make that part of our investigation. If there is a secondary document, or if there's the document coming from the mayor's legal counsel, would that then be something we would kind of put together as a packet to say these are the things we are considering as quote unquote like evidence or support?
So, in answer, if I may,
Sure.
we need to remember where we are in the process. We're conducting an investigation in order to make a probable cause determination. It's not to make the final determination on the complaint. We're still preliminary, and we're working toward a second preliminary step, which is a probable cause determination. I think we need to be very clear. We may want a whole lot of information if this ever reaches the point of having a hearing, but we don't need that now. Well, all we need is those facts that are going to help us make our probable cause determination. So I don't know if that helps put your question in focus, but we operate under a microscope, like all government does. And yes, we're generating public records all the time. These documents that are circulating around the dais are public. Every public record issue has the component of there needs to be a request. The request needs to be analyzed. There will be some situations where the analysis will result in redactions or it will result in not disclosing it. So I'm not going to tell you that everything that happens or that we might receive is going to be handed out to the public, but it may well be.
Sure. It was just a point of clarity, really, more than anything else,
Yeah.
procedural.
And what we're talking about with this particular proposal is simply letting the respondent have his say in response to the complaint, whether it's that 8-page document
Right.
that we haven't seen yet,
Right.
or whether it's that plus of specific responses to the allegations. It's up to the respondent. We're not going to, it doesn't hurt the respondent to either not respond or to respond in whatever way they feel is appropriate. We'll take it. We'll take a look at it.
Let me ask this, because I think I know where I can get that document. Supposedly the clerk has it, and I want to be allowed to get there or bring that to us.
Well, you
So-
Whether he does it or not, I want it.
Okay, well, you
here's
should
my-
be able to get it.
I just want you to be aware that your code prohibits ex parte contact.
Ex parte is
It means outside of the hearing.
outside there.
So it says, if the board during the course of an investigation finds probable, no, I'm not listening to
Well,
reading
as
the
far
right
as ex
section.
parte contact, Attorney Larson, if Doug is simply going to the clerk or wherever he thinks that document is and he wants to get it, I guess I don't see that as ex parte contact. But if he goes to the respondent and sits down and says, gee, what's your response? That's what I would say is improper ex parte contact. And it would violate the no contact order that we have in the resolution we just passed. So just to stay on track of what we're discussing here, whether you go and get it or not, that's not really what we're talking about here for this
Right.
proposal.
Something
The
else.
proposal is, do we give the respondent an opportunity
Right.
to respond?
Let's stick to that, yeah.
And if
So-
so, what deadline?
That'd give you-
Yeah, I recommend that if you want that document, you can revise section 1 to ask them for it. Because,
Okay,
again, your code says that they are prohibited from contacting you.
Who's they?
The respondent and the respondent's agents, including the respondent's attorney,
Right.
is prohibited from contacting you.
But if he says he can get it at the clerk's office, he's
He
not
you should
contacting
not be
the
doing that. You should not be gathering evidence
Okay.
outside of
Right.
this process.
but then, so if we change this to say that we can add, or can add that.
You can add
we
to
would
item
ask
1
them-
that you
Right.
want to receive that, and then it can be provided to you.
Okay. If we can do that, I'd be happy with that.
Well, are you moving to amend the proposal? then?
Yeah, I would move to amend their proposal to say that we ask the respondent to provide the reasons that are given for his actions not being illegal, not violating the law. We ask that, and as part of your motion, ask specifically for that. And then it's up to him.
Is there a second?
Is there a second to that?
If we're going to revise it, should we add in that date, the
Yes.
deadline as well?
Right.
Which I think you had offered 7 days. I thought, just looking at the calendar, just a little bit more time giving till the end of the month, February 28th, just making it nice and easy. It's, 9 days, I think.
Okay.
Okay, we've got two
Okay.
proposals basically to amend
Well,
what's
okay,
been
but I'll
proposed.
change my proposal and include the 28th.
Okay, thank you.
If that's okay. But Cody, is that all right? Is that making any sense? I made the motion, I restated it, so it included that, and then Robin seconded it.
And I will second the revised motion to include then no later than February 28th, as
Right.
well as asking within the request for admissions or denials to also ask for a copy of that letter that was submitted.
Okay, well, we've got a motion to amend and a second, a
Right.
two-part second. And I agree with the February 28th
Okay.
sounds fine to me, but I disagree with the other part of it.
Okay,
I mean, we're inviting the respondent to give us what
Right.
he feels is appropriate.
right. But I personally will not be satisfied until I get that.
Okay,
And
and-
that's why I want to make it more likely he does that.
You're going to make it more,
That's-
what if he doesn't do it?
Then we're done. Then I don't have what I want.
Okay.
But I try to ask for it in a appropriate way.
I tend to expect he will provide that to us, but I don't see the need to add that to the proposal.
So to keep the proposal as narrow as possible, because I think that's key here, we really are just looking for a response from this moment forward, right? Like, whatever has been said on his behalf or he has said in the past, that's what is being discussed here. I think it's more important that we're looking for a statement in response, right? So from this day to the 28th is when we'd like to see his response.
Oh, during that time, yes, and it would be whatever response he deems appropriate,
If there's a pre-discussed response, that's fine, but if he wants to offer a different, that's great.
or a combination of the two, whatever he
We're not
thinks is
narrowly
appropriate.
making- yeah, okay.
And I don't see a need to ask him for anything beyond what he thinks his response should be. But, you know, we have a motion with those two parts right now. So I would suggest we split that motion up between those two parts. First, let's vote on the date. If we can do that, everybody okay with that?
But
We would amend the proposal to add in the date of February 28th, 2025 for a deadline for a response.
Okay.
If that's okay,
So you want the second part of the motion to make that separate?
make it separate. so we
Okay.
can-
That's all right. As long as I get what I want, that's all I get.
All right, all those in favor of adding that date of February 28th,
Say aye.
2025 as a deadline, raise your hand. That's unanimous. Now, let's move to Doug's point. I guess I've had my say, he's had his say.
Okay.
Other discussion on that part of the motion?
That it would read that we ask him specifically for that.
Okay, with that
The specific.
motion to amend is to add a request to this
Document, yeah.
proposal that that the respondent be asked to provide his legal analysis or the document he provided to who?
Documents that's in support of saying he did not violate the law.
Violate the law.
Because that's what I need to see.
Okay. Well, let's make sure we've got the wording down, wording accurately. So,
See what code.
amend to request the respondent provide
Right. The arguments or the reasoning in support of his not having broken the law or violated the law.
So it could be more specific. It could say the letter dated January 27, 2025,
Okay?
provided, addressed to the City of Wausau Common Council from Attorney Joseph Bugney.
Okay, excellent.
Thank you.
Yeah, thank you. That's really helpful. Thank you.
Very helpful, yes.
Yeah.
All right. Any further discussion on that amendment, proposed amendment?
That's
All
been
those,
made. Is that made, you second that or what?
Sure, I'll second that.
Okay.
all right, are we ready to vote? All those in favor, raise your hand, please. And opposed?
Okay. Okay.
The motion carries. That will be added to the proposal.
Okay.
Thank you, Doug.
Okay.
The next proposal is for the board to include in its orders implementing the investigation the following order. It is ordered that the respondent, the Wausau City Attorney, and the Wausau City Clerk provide the board with copies of any written documents, including email messages, that they may have transmitted to or received from each other in 2024 that discussed absentee ballot drop boxes. Is there a motion to adopt that proposal so we can discuss?
Go ahead.
I'll make the motion.
Okay.
Ryan has made the motion. Is there a second?
I'll second.
Jesse, second. Thank you. Any discussion on that proposal?
Chair, I'd ask that we amend it from 2024 to all correspondence from 2024 up to today having to do with the matter, and not limit ourselves to communications just from last calendar year.
Okay, up to the present. So so the amendment, the proposed amendment is to change the wording so it says any documents they may have transmitted to or received from each other in 2024 and up to the present date that discussed absentee ballot drop boxes. Is that accurate? Is there a second?
Yeah, I'll second it.
Pardon me?
Yeah, I'll second.
Okay, it's been seconded, moved and seconded. Any discussion on the amendment? No discussion?
Sorry, this more or less, we're just including the last then month and a
Right.
half
Yeah.
in addition to 24, right? That's the whole point of it? Okay, thank you.
Right.
Just making a note here. All right, are we ready to vote on the motion, on the motion for an amendment? And that amendment is to add after the number 2024 to the present.
Up to the present.
So bring it up to date.
Yeah.
All those in favor, raise your hand. That's unanimous. That motion is carried. Now, any discussion on the motion or the proposal as amended? Seeing none? Oh, go ahead.
Time periods for requesting these documents?
That is covered in a proposal at the end,
Okay.
and that's something we'll have to, but that would be like a separate order, so
Okay.
unless otherwise stated, everything in here should be provided by a certain date.
Thank you.
Okay. Any other discussion, questions? Seeing none, we'll bring this to a vote. All those in favor of the proposal 2 as amended, please raise your hand.
Okay.
It's unanimous.
Okay.
Then we would move on to the next proposal, and that is that the order implementing the investigation include the following. It is further ordered that the city attorney provide a sworn statement to the board setting forth in as much detail as possible the date, circumstances, and content of any legal advice she may have provided to the respondent, verbally or in written form, relating to whether a mayor would have the legal authority to make decisions about or to take action relating to the placement of an absentee ballot drop box, and also relating to whether the respondent might violate any federal or state election or voting laws if he removed an absentee ballot drop box placed by the city clerk during a period in which absentee ballots could be cast in the election. Is there a motion to adopt?
I'll do that.
Thank you, Doug. Is there a second?
That's exactly kind of what it was. No, one of my interests was that. Just to get a
Second.
Timeline.
Brian has seconded it.
Timeline.
Any discussion on this proposal? Kind of seems to get to an important point. If there's no discussion, we can call the matter to a vote. This proposal, ordering the city attorney to provide a sworn statement. All those in favor, please raise your hand.
Right.
Again, we've got a unanimous vote. Then we move to the next proposal, and that is that the order implementing the investigation include the following. It is further ordered that the city clerk and the respondent provide sworn statements together with any supporting documentation, including email, describing in as much detail as possible any discussions that the city clerk and the respondent might have had with each other about drafting a resolution to the Wausau Common Council about an absentee ballot drop box, or about a directive from the respondent to the city clerk to seek advice and consent from the Wausau Common Council about an absentee ballot drop box. Is there a motion to adopt this proposal?
Want to go over the, we can't talk about that until we move it.
Motion to adopt.
It's been moved. Is there a second?
Second? That's good.
I'll second.
It's been seconded.
So we can discuss it.
Attorney Larson?
So I have some concerns with ordering the respondent to provide a sworn statement.
Right.
We're not in a hearing, and in a hearing, they can decide whether they're going to testify or not.
Can we request versus
Well-
ordering in this case?
I don't know. I'm not sure I have that same problem. I mean, this is not a criminal proceeding.
So,
It's not, but at the same time, we are only trying to determine probable cause.
right.
We're not conducting the hearing. So I'm a little concerned that we might be getting ahead of ourselves in, having all the evidence we need to make a final decision at trial or at the hearing, when all we really need is to determine whether there's probable cause.
I think if we have agreement on the issues, I don't see any reason for not to look beyond a probable cause determination. I mean, if we've got more than we need for a probable cause, that's not, I don't see that as a problem. And I think that if we've got evidence, usable evidence, sworn statements from persons involved in this matter, that can narrow the extent of what we might need to cover in a hearing.
Well, my recommendation is that you revise this so where it's referring to the respondent, it invites the respondent to provide a sworn statement that responds to these, but it doesn't order him to do so. And you're correct, this is not a criminal proceeding. However, we are aware that there is a criminal investigation being undertaken. And sworn statements are sworn statements.
That's true.
Yeah, okay.
Well, if the mover and the seconder will agree, I mean, I bow to your superior knowledge of municipal law, and what you're saying makes sense, too. I mean, there is a criminal proceeding, investigation rather, going on, and sworn statements are sworn statements. So I think it would be wise to change any order of directed to the respondent for a sworn statement to an invitation.
Or request. Okay, you can request.
Request.
Yes.
Then we would rescind the motion and then go back a step and revise?
Well, we haven't,
If the mover and the seconder are willing to make that change.
Can we ask, instead of asking, even inviting a sworn statement, just a statement? I mean, does it have to be a sworn statement? I guess I'm just asking.
right.
Yeah, I think that's a good point. If we're not going to require a
Right.
sworn statement, why ask for a sworn
Right, yeah.
statement?
Right. I like that.
That makes sense. Jesse, are you in line with this,
Yeah, I'm amenable to
these
that.
changes? No, if no one else has any objection, we can take that as
Okay, so
a revised motion.
the motion would, and we're inviting the city clerk too,
No, that would be a sworn statement. City clerk is not.
really?
I mean, if they're put on the stand at a hearing to testify, it's sworn.
Right, but see, what I'm thinking is, I want to learn about it, but I'm not sure how much I want to demand it. I mean, I want to ask them, they don't want to respond, then they don't want to respond, including the city clerk. And I would say, here's something we need, we would really like, we would prefer this, but we want to demand it of you.
I don't think we have the ability to order. I mean, I'm looking at our code of
Right.
conduct, and I think it is to require any person to submit in writing such reports and answers to questions relevant to the proceedings conducted under this session. I think that there's no force behind that, so according to the rules that are laid out for us, that
What
would be
section?
2.03.60, section B, line 1.
2.03.075, investigative powers.
Okay.
Pursuant to any investigation or hearing conducted under this chapter, the board has the following powers and authority and administer oaths, require by subpoena the attendance and testimony of witnesses and production of documents. I think we have ample authority there to do that, but the question is, better question may be whether we should at this point.
Sure.
And what you're talking about, Doug, sounds like change the whole thing to not sworn statements, just ask them to provide
Right,
statements.
Right. I'm gonna want to find if they don't.
I guess that's what I would like to see as well.
Jesse?
So if that's the intent, I think you can just resolve it in the first line of paragraph 4 to revise that to say, it is further ordered that the city clerk shall, and the respondent is invited to provide statements together, strike sworn, so it'd just be statements together with any supporting documentation, et cetera.
Is that okay?
Is that acceptable to the,
To Robin?
Well, it's the movement. I think
The
were you the
movement.
movement, Jesse,
Yeah,
in the
no,
first
that's-
place? Okay.
I think that that's a better choice. I think that's, the wording on that seems to be more inviting. Is that the
Right.
term?
sure.
Yeah.
Is that good with the second?
I don't think I second that. but-
Oh, is that Brian? I'm sorry.
Yeah, I accept it as, based on council's advice.
Right.
Right.
Friendly amendment. Okay.
Thank you for the advice, once again,
Yeah,
Attorney
I
Larson.
appreciate that.
Are we ready to
Vote.
vote on this then? All those in favor of the proposal as revised, please raise your hand. All right, let's see, what do I have next?
Further ordered that the city
Oh,
clerk.
the long one, yeah. It is further ordered, and maybe we should change this right away, that the city clerk and the respondent provide, okay, that the city clerk shall,
And the respondent is invited.
and the respondent is invited to provide
Statements. Identifying. to
bear
us.
with me a little bit here,
Yeah.
to provide statements,
Or kind of.
not sworn statements, but statements, identifying to the extent they have such personal knowledge the following. Paragraph A, the date, approximate time, and circumstances of, number one, the initial placement of any absentee ballot drop box placed outside of Wausau City Hall for use in the November 2024 elections.
And the return.
Number two, any subsequent removal of any such drop box from outside of Wausau City Hall. And number three, the return of any such drop box to the place it was removed from outside of Wausau City Hall. Paragraph B, in addition, if either declarant has knowledge of the locations of the drop box during any period after it was removed from placement outside of Wausau City Hall, the declarant shall identify each such location and the dates and times it was kept at such locations.
To the extent of their knowledge.
To the extent of their knowledge, right. We want to know where it was, when these things happened. We want to be able to have a timeline. In addition, the statement shall provide any information the declarant may have about whether the drop box was locked or had anything inside of it as of the time of the initial placement of the drop box in September 2024 through the return of the drop box to its location outside of Wausau City Hall. Paragraph D, the statements must identify the basis for the declarant's knowledge of any material facts included in the declarant's statement. So it's a little, it sounds a little formal since we've now revised it to be more, please provide, as opposed to provide sworn statements. But there is quite a bit to it. I recognize that and invite comments from the board or from Attorney Larson.
I guess I'm not, I don't know all the facts yet, as
Right.
neither of us,
Right.
none of us do.
Right.
But I was just concerned about that, the September 2024 date, where it says at the time of the initial placement. I guess that's maybe a question I would have rather than of when it was initially placed, rather than a statement in here, whether or not that's true. I don't know if that was true or not.
Is that part of, is that part of the complaint, or is that not? Is that the language that comes over from the complaint in this case, or is that an assumption?
Yeah.
Oh, maybe it is.
I
I'm not
think
sure
the
how that
complaint
has-
does identify September 2024,
Okay.
but, yeah, that's a good point, Attorney DeVos. Yeah,
Yeah,
that did look a little out of place when you're initially asking for the dates.
Yeah.
And later, it seems we're assuming a date. We kind of are, but I'm pretty confident that that is alleged in the
Okay.
complaint.
but we can ask them to tell us from their knowledge
Yeah.
what it was.
We
Yeah,
wanna
because
be-
I want to, if the client makes the claim, I would like to see some verification. Exactly.
Right.
So,
Any, let's see.
Just, we start using the words declarant, and I guess I just wanted to make sure that it's the declarant is either the city clerk or the respondent, whoever's answering it
correct.
is considered the declarant.
That's correct. Let's see, do we have a motion to adopt this proposal?
any,
I think it would, I don't know that the date of September 2024, I think it should probably be taken out. And we should just ask the information about when it was removed and so on, because I don't know when it was removed. I mean, I've read the press, but I'd be interested to see the timeline in the statements. So I think it could just say the time of initial placement of the drop box and strike out in September 2024.
Okay. Actually, I don't think I think your point is well taken, both of you. And, but I don't think we have a proposal that's been moved and seconded, so we're kind of getting ahead of ourselves with discussion right now. But maybe this is just for revising, well, let's go. I'll make the motion that we adopt this one, but I will take out that in September 2024 out of the proposal. How's that?
Okay, and I would second that.
Okay, it's been
And
moved.
to be clear, you're also modifying that very first line as you said when you were
Right.
describing it.
Right.
Yeah.
We'll talk about the city clerk shall and the respondent is invited to provide statements identifying to the extent they have such personal knowledge. So no sworn statements.
Yep.
All right. Any further discussion on this proposal? Seeing none, I'll ask for a vote. All in favor, please raise your hands.
does it have to be my right hand?
Unanimous. No, it doesn't. As long as we can tell.
Because I'm a left-handed person.
I see.
See,
I don't think I said right hand, did I?
no. Thank you.
All right. Then we have a proposal that this order include that all documents and statements ordered to be provided shall be filed with the city clerk no later than, and we need to set a date.
Well, they're ordered, we have to get rid of it, don't we?
No,
Well, it's requested.
it's our order. It doesn't, it's no longer ordering sworn
Yeah,
statements.
it's further ordered, yeah.
Yeah.
All,
Anybody want to propose a deadline for this kind of stuff?
30 days?
I think that's longer than we need. I guess I'll propose 14 days.
2 weeks, yeah.
14 days from
The date the order gets,
filed with the clerk, right?
yeah, well, we're going to need to talk about what form the order is supposed to be in and how it gets to who it's supposed to go to.
Okay.
We will have to talk about that, but I would say, as of the time the order is actually delivered to the parties, or the people it's directed at.
Attorney Larson, would you be willing to draft that order for us?
Yes, I would, but we should talk about logistics. Do you want me to draft it and bring it back for you to review it
Could be.
and then order it? Or do you want to direct me to take these paragraphs that that describe your order and just put that into a format that can be signed by the chair.
Yes, please.
Yes.
And the vice chair.
And I think we would need things like documentation as to when delivery is made, so, and we need to decide who's going to deliver it. The clerk is actually one of the people who the order is directed at. So that's where I think we need some more advice from you, Attorney Larson, and that is, who should be delivering that? And,
I'm just checking your ordinance to see if it speaks to that issue.
I think in previous ones, it was delivered to the clerk and they forwarded on to us, yeah.
Like to the deputy clerk? It was probably-
So for your investigations, it says a copy of the resolution shall be mailed to each respondent. Service of the resolution is complete upon mailing.
So would that be certified letter in this case then? Is that?
well, you were talking about the resolution first.
That's
right?
the resolution.
Yeah,
That's not
and
this order.
Let me ask you
But
this.
they are related because the resolution is concerning the investigation.
Yeah. Where was I going with that? Yeah. Is it your opinion that it has to be mailed? It can't be served on them by just delivery? Like, I mean, they're all in this building. To mail it and wait for the U.S. Postal Service, which is getting slower all the time.
It goes to Green Bay and comes back.
Yeah, it's got to go to Green Bay first and then come back here.
Which is only fair and just.
I would think.
Well, there's the practical answer and there's the legal answer. Yes, it should be mailed because it says mailed, but it can also be handed to them.
Could be done, both could be done,
Yes,
yes.
yes.
Yes, excellent. And then we come to the question, who would be proper to deliver here in the court?
I think the deputy clerk could do it.
Deputy clerk, I was
Yeah.
hoping you'd say that.
What do you think?
And then he could make note of when he made the delivery and
Yes.
that kind of thing. And the mailing, because he'll be doing the mailing as well.
Right.
Thank you.
Yeah.
More, did you have more to say on it?
No, so just to summarize, I will take your order, your various orders, put it into a format that can allow it to be signed. And I assume it'd be signed by the chair and by our secretary or the deputy clerk, but then the clerk would deliver the resolution and the order probably together to, as indicated, to the respondent by mail and in person, and also to the clerk. Doesn't have to go by mail to the clerk. It can just be handed to the clerk.
Right.
Thank you. Yeah, thanks for addressing that. And also, do these things get signed? I appreciate your addressing that as well. I think that's important.
Yeah, the resolution should also have a signature line, be signed, and as also the order.
Yeah.
So going back on the timeline too, I'm now concerned with depending on your timeline to draft it up, that first number that we gave by February 28th, is that still doable for you to get it out within a day or two?
I can help.
Unfortunately, it would have to be my staff working on it because I'm not going to be available until Monday.
Yeah. It just brings me back to that first. I just want to make sure we give time to, for the respondent to properly submit an answer. And now I'm realizing as we talk about this, whether February 28th is too early, depending on when the resolution and order gets done and drafted.
So would we then return to the 7 days
I think so.
guideline versus having a date in place? Yeah.
Yeah, I apologize. I think that makes more sense to have a date from the date of the order versus an actual.
Yeah, I agree.
I apologize.
That's
So we should.
no problem.
Full circle.
Any
We got there.
objection to making that change? Why don't we vote on it
Yeah.
Just to
To
be
make the
clear.
change, yeah.
So that the deadline for filing a response by the respondent
Right.
will be done within 7 days after
The date of this
the
order.
date of the order. All right, all in favor of that, please raise your hand.
Okay, yeah,
It's unanimous.
okay.
And then going back to 6, we still have to figure out that date. So Calvin, I apologize, I forget what you had suggested.
I suggest 14 days from the date of the order. And that's something we need to vote on, so
Was that one moved in?
I don't believe so. Do we have a motion?
I'll move to adopt your number 6 here with the 14 days.
Is there a second to that motion?
Yep.
I'll second.
All right, been moved and seconded. Any discussion? Seeing none, all in favor of that proposal, please raise your hand.
Right.
One of them.
But,
It's unanimous. All right, let's see, housekeeping issues. You brought those up, and thank you for that. Any board member have any other matter they would like to be heard on before we proceed to the next agenda item?
Yeah, I was, this is pretty vague. One thing I wanted was some contact, if there's any, we can make with the Attorney General's office, because they're doing an investigation. And I would, number one, like to see if they have any thoughts on whether the actions were illegal. If they have not come to conclusion, that's okay. At least I'd like to find that out. If they thought it was a violation of law, that would be important to me. And maybe anything else they want to discuss. I would say that that involves our advising attorney. Because I talked to Josh Call today.
Did you?
But, well, I'm a really highly connected. Okay.
sounds like it,
No,
yeah.
no, no, that's facetious, okay, that's very facetious. Josh called me, but it was for money for a campaign. And so I said, now that I've got you on the phone, this is what I'm interested in. He said, I can talk about political things, but I cannot talk about that case. And the only person who can talk about that case with us has to be an attorney. Has to be, and the advising attorney would be the one that would have
Right.
to talk.
Yeah,
And he
that-
may want not to do it, so I don't want to ask him to do stuff he doesn't want to do.
Well, I can tell you that I have talked with the investigator. I don't want to go further down that hole because it's not really, we're getting ahead of ourselves to talk about that. Just to, their investigation is not complete. That's the bottom line. But
I think,
we need to be cautious to let the evidence come to us. We should not be going to look for it. The only exception being when we are initiating the investigation, as you've done. That, you can do that, but please do not go out and seek information outside of our proceedings. So we can talk about the interaction between our proceeding and the state's proceeding, but that we're a separate body, and we need to do our business the same regardless.
And the legality of the issue isn't what we're really debating here, right? That's important to acknowledge. We're talking about the ethical implications of how our city conducts itself, right? That's what we're reviewing. So really, we're relegated to our code of conduct.
Exactly.
Discussion.
The state has nothing to say
Yeah.
on whether our ethics code was violated.
Correct.
Just like we have nothing to say on whether there was a criminal violation.
Thank you.
okay, accept that. So we got that.
Anything else on this agenda item?
No.
Well, then, I think we can move back to item number, on the agenda, item number 2, approved minutes of previous meetings. And we got those in the packet. Thank you very much.
Yeah.
Really appreciate that.
Right, thank you.
Thank you.
Very valuable advice.
No.
And I'm grateful we have that. I'm very grateful we have that. All right. So approving the minutes of previous meetings, we got those in the board packet. Is there a motion for approval of those minutes?
I would move to approve.
Second.
It's been moved and seconded. Any discussion about the minutes of those 3 previous
Do you
meetings?
have
Me?
any observations you made?
Well, one thing that I thought about is, these minutes were basically produced after listening to tape recordings of those 3 meetings. Is that right, Cody?
That is correct.
Right.
Thank you. I don't remember that much. I mean, I remember
Right.
highlights from the
Right,
meetings,
right.
but not details, so
Right.
I don't have any particular comments about whether the minutes are accurate or not.
Just a matter of housekeeping is, did Kay leave because she's just recusing herself from that issue, right? Is she?
Yeah, she would be eligible to participate in this part of it,
Okay,
but with her absent, we still have a quorum, so.
Right.
okay.
And also, all that's required for Jesse is absence, I think.
So in this instance, and I was just looking over the recusal rule, so at this point, my involvement is more or less strictly resigned to the discussion about the complaint, or is it more that it carries into
Well, I thi-
like
As I read
approval of the minutes and
statute,
things of that?
We
nature?
just read
It's
it.
just absence.
Yeah, I'm just looking at it, yeah.
You don't have to.
Which
recruit.
one is that?
It's the second minutes from October 7th.
Oh, actually, I'm talking about the
Oh,
authority of a,
Of alternate.
of the alternate.
If a member, it's under 2.03.040, and it specifically says alternate members shall act with full authority when a member of the board is absent.
Oh, yes.
So I just wanted to make, sorry, a little bit of housekeeping to
Thank
make
you,
sure
Robin.
if Kay was
So
here
you
still
can
or not.
Point
Right.
well made, thank you.
Right.
Okay.
But then, so Jesse can still vote,
Yes,
right? I'm
Just
hired.
absence.
I am here.
And thank you for bringing that up,
Yeah.
Doug,
Okay.
as well. All right, any further discussion on the minutes?
No.
All right, well, we can bring this matter to a vote. All in favor of approving the minutes, raise your hand, and I will abstain.
Okay. Okay.
Just to
Good.
mix it up a
A lot of people don't abstain.
little. You don't see that often, yeah.
It's a huge-
Then, the next agenda item, let's see, where did that go?
That's your-
Next agenda, I lost my agenda.
Well, here it is.
Thank you. Next agenda item would be discussion and possible action on adoption of rules as may be necessary to carry out the duties and responsibilities of the board for the annual term.
Right.
Thank you, Doug. And the board's packet includes the recusal rule that has been discussed for over a long period of time. And I'm not aware, I mean, does anybody have any other board rules they would like to discuss? 'Cause we've not had any before us. That's the only one we've discussed in the past.
It's been and discussed at length.
Yes,
We got there.
great length. I would like to note that we've discussed it for so long that there is a typo on it. It refers, I don't have it in front of me now, but it refers to the, I'll get it in just this, oh, that's not it. Hang on, bear with me, please. Word packet, there we go. Okay. The rule on recusal, if you go to section, the last section, section 7, enforcement, it deals with member refusing to comply with mandatory recusal requirements And under A, paragraph A below that, it says, proceed under Ethics Code Section 2.03.060, paragraph C. That paragraph C should be dropped because when in January of 2024, the code was revised by adoption by the Common Council, the changes made that reference to paragraph C inapplicable. But that section itself, 2.03.060, is still appropriate. So if we could just delete that, if we could have a motion to delete that paragraph 7, I will make that motion, not to delete under paragraph, or section 7, that reference to paragraph C on the code section.
I'll move.
All right, is there a second then?
Sure, I'll second.
Thank you. All in favor, if there's no further discussion, please raise your hand. So with that correction then, is there any further discussion on the recusal rule? All right, that's understandable. Then we'll call a vote. All those in favor of the recusal rule and asking the city attorney to submit that to the Common Council for approval, please raise your hand. Okay, that's unanimous. And just to note that the ordinance does require that any rules adopted by the Ethics Board are subject
Chair.
to the approval.
Chair, that needed a motion and a second.
Okay.
The amendment had a motion and a second, the
Oh.
rule did not.
Oh, the main motion we did not vote on yet? All right, well, let's,
Thank you.
is there a motion and a second on the main
Yeah,
proposal?
I can do that.
Doug is moving and somebody is seconding, I assume.
Second, yeah.
Yeah.
Oh,
So
Brian.
this
Thank you,
side
Brian.
is going to speak.
All right,
up.
thanks for pointing that out, Cody. We want to make sure we do this right. All right, so the motion is to approve that resolution, or, I'm sorry, to approve that recusal rule and ask the city attorney to pass that along as a resolution for approval to the Common Council. All those in favor of that motion, please raise your hand. We have unanimous vote. All right. Then,
That
the next item on the agenda
would be, looks like adjournment. isn't it? Oh,
is
discussion possible action schedule.
the recommendations
Let's see.
that we've been talking about for, seems like forever as well, to the Common Council for changes to the Ethics Code. Including, I might note, there is a recommendation for further change to paragraph J, which is the subject of the complaint we've been dealing with. Let's, before we start discussing, let's see if anyone wants to make a motion regarding the recommendations of the council for changes to the code. Do we have a motion to approve that, or,
Yeah. don't we want to approve it?
all right?
I'll
Is there a
make-
second? Doug
I'll
has
I'll
moved,
second.
and Robin has seconded it. Is there discussion on this?
Instead of, something I was curious about, as we discuss this and the complaint currently reflects the current nomenclature for J, is that something we want to table till after we are through this process in order to avoid any kind of conflict where J no longer represents what the complaint was actually trying to say? Or is that like, from this day forward, if the city adopts, does that matter if it changes?
Yeah, I don't think this is an ex post facto kind of thing.
Sure.
I think that the complaint would still be decided under paragraph J as it existed at the time of the alleged violation.
Right.
However, as part of the discussion on this, I don't think it's appropriate for us to be trying to forward recommendations for changes to the ethics code at a time when we're dealing with an alleged violation, a complaint alleging a violation of the ethics code, especially not paragraph J.
Specifically, yeah.
I don't have particular concerns about the rest of it, but, that I think
So that,
Well, I guess I would disagree. If it's not retroactive, so it'd be only under any new complaints filed. If it is adopted by the common council, it'd only be as of the date of the adoption moving forward for new complaints filed. So I guess I don't have that same concern.
You guys, any thoughts on the matter?
I'm listening to you, Jim.
I still feel that way, that, well, there's enough controversy going on right now as it is.
Sure.
And why
Well, that, yeah, different.
pick at the scab, basically, by asking the council to, even if we didn't ask the council, I just think it's better to kind of put this aside. We got the more urgent matter of the complaint itself to deal with. Let's not.
So we would just table this until after this complaint is fully processed and table the entire request? Or are you saying just table J?
Well, I don't have a problem with tabling the entire request, but tabling J would be the main thing, I think. I don't know if we want to be asking the council to start a debate at city council meetings about amending the code.
Yeah.
It's one thing to have that recusal rule. All they have to do is say, it looks okay to us. And that's not really
It's okay.
at issue here, but as far as what the code says or does, I kind of like to see that put on hold,
I think it invites discourse that wouldn't be helpful to us or them at this point. yeah.
or the community, right?
So we just leave that.
Right.
I would vote to, or it's not a vote, but I would recommend that we table it as well. And then, in light of what often happens when I have an immense amount of time to consider possible changes, I would estimate 200 words to share with this body of suggestions that I would make to the proposed changes, which lends itself to the more conservative approach of tabling this particular agenda item in light of what's been discussed and my own recommended changes that I would make anyways. That's my 2 cents on the matter.
Would appreciate getting that 2 cents.
Yeah.
Any other discussion? I think too, along the lines of what Brian was saying, that a lot of things occur to me that we could be looking at for changes in the
Right.
code. And in fact, I've got a relatively lengthy list, I think, of changes. Some of them are fairly small.
Right.
Some of them are more important.
Right, like the idea of starting an investigation.
And it doesn't mean that we have to figure out everything all at once. I mean, it's not that these can't be sent on, but at this point in time, I think, I just feel more comfortable if we put those aside and focus on this complaint.
Yeah, and then come back and do that.
All right, so.
So how do we table versus actually opposing the motion that's on the floor right now?
I think we can, rather than table, which actually isn't open to debate, you can, at least that's my understanding. I've got my Roberts Rules of Order here, but
Right.
I'm no expert on that, not anymore anyway. You can move, there can be a motion to postpone to a later date or event,
Right.
and that's, I think, what we're talking about doing here.
I was gonna say, and a motion to table supersedes the motion.
Okay. Thank you.
Thank you, yes.
Cody.
So I guess I'll move to postpone until we have resolved in one way or another the complaint that's before the board,
Right.
that we table this particular item of the agenda, not table, that we postpone this particular item of the agenda until that event.
I would second that.
Any other discussion? Seeing none, let's have a vote. All in favor, please raise your hand.
There we go.
It's unanimous.
Thank you.
All right, I think the next thing we need to do is consider scheduling, see if we can schedule
Right.
another meeting of the board. We'll have, I would recommend we look at not having a meeting until after all those things we've asked for come back.
Right, that's for sure.
And
That would be when.
We'll have to work with Attorney Larson's schedule as well.
that's right, right. We
Attorney
can't
and with Kay's schedule.
disregard that either, but maybe we can be talking about a target week or something.
Yeah, I am, just as a heads up, Wausau School District has spring break in March. So I will be gone March 19th
Okay.
through the 26th.
So we would look maybe towards the very end of March or the beginning of April then? to give us enough time for those two spans of time with the 7 and 14 days.
Yeah. It'd be nice if we could get something in ahead of time, but I'm not sure by the time everything gets out.
Yeah. So we're thinking the end, after you get back, Robin.
Yeah,
So
I'll be I'll be in Wausau on the 27th. Oh, 28th, I apologize.
28th of March.
March.
28th of March, yeah.
Okay, it's a ways off.
And like through the first week of April, kind of a target for us?
I would be available the first week of April.
And we'll need to talk to Attorney Larson about his schedule. Anybody else have, they know they're going to be gone during that time period?
I'd have to, I guess, if I could go on my own computer, I can. find
Yeah,
out.
I was thinking the same
Yeah.
thing.
Yeah, I don't know if we can do virtual appearances or anything like that
I don't
on the,
do that.
I'm not
okay,
sure.
I just do not do that.
yeah.
I would be amicable to doing the first week of April there. I'm pretty wide open. I will be in town.
Brian, that looked like it could be okay for you?
It works.
Yeah, well, the first week is usually pretty okay.
I don't have that much on the schedule. Yes.
Yeah, and so we'll just leave it for the first week, kind of have a goal for the first week of April, it sounds like. I have another question as our terms are expiring.
Right.
And what happens if we're in the middle of a complaint when our term expires?
Well, that's one of the reasons I think it's important for us to do this as expeditiously as we
Right.
can. I don't know. I mean, that's a question that I
One
think
of my
we
hunch
need-
is that we disappear.
we need to pose to
Yeah.
Attorney Larson.
Okay,
Correct.
Yeah,
So I don't know.
okay.
I don't know.
yeah, I don't.
And the terms end the end of April, right?
I think mine and Doug's
Right, the
April
end of April.
end of
Yeah,
April.
and it's basically I think it's pretty much the mayor's prerogative to assign, to bring forth new names, and that's what I'm used to. Council has to approve it,
Yeah,
but I think, I'm not counting on being, the mayor doing it.
Yeah, and the
I mean, I'm
real
not-
question
I'm
is,
not-
what if we have a new member on
Yeah.
who hasn't participated up to that
Right.
point?
They
And
have to-
maybe it depends on how far along we are with it,
Right.
yeah.
whether there can be any.
Right.
Maybe a
Gotcha.
code change in the future.
Yeah, like I said, going through this experience, we learned, and maybe that'll help us make some recommendations to improve the code. All right. So Cody, I guess I'll be in touch with you very soon about checking with Attorney Larson and, who's going to do what. All right. Anything else anyone wants to bring before the board?
Nope.
Seeing that there is not, we'll entertain a motion to adjourn the meeting.
Okay, so move.
It's been moved. Is there a second?
Second.
Moved and seconded. All in favor of adjourning the meeting, raise your hand.
Okay.
It's unanimous. Thank you very much, and thanks to the audience as
Thank you,
well.
everybody.
Right, thank you for your behavior.